Employment contracts are more than just paperwork. They define the essence of your job. But what happens when circumstances change? Understanding how to amend these contracts legally is crucial for both employers and employees. The main ways in which a contract of employment can be changed include: by mutual agreement. The safest and most legally acceptable method is for both the employer and employee to agree to the changes. Changes must be based on consensus and can relate to duties, remuneration, hours of work, or other conditions. Variation based on contractual provisions. Some employment contracts include clauses that allow for certain unilateral changes, such as changes in the place of work, within reasonable limits. However, even then, changes must not be unreasonable or prejudicial. Through collective agreements, changes can be negotiated through a trade union or bargaining council agreement, especially in unionized workplaces. By operation of law, changes may be imposed by new legislation or court rulings that override existing contractual terms, for example, national minimum wage laws. Unilateral changes without agreement. Generally, an employer cannot unilaterally change material terms and conditions of employment without the employee's consent. Doing so may amount to a breach of contract or an unfair labor practice. Employees may have remedies, such as claiming constructive dismissal if changes are forced upon them unfairly. When applying changes, employers must also consider fair labor practices under the Labor Relations Act to avoid legal disputes. In conclusion, changes to an employment contract must typically occur by mutual agreement, collective negotiation, or lawful operation of contract clauses or law. Any unilateral amendments risk breaching the contract and violating employee rights. Thank you for joining us.